Professor Elliott, dear friends and colleagues, dear students, ladies and gentlemen. In the middle of volume 7 of his 12-volume multi-civilizational study of history, published in 1954, Arnold Toynbee finally reached the significance of law. Having traversed the codification of law from the Digest of Justinian to the Code Napoleon, he reached the following general conclusion. He said, as a rule, and this rule is inherent in the very nature of the declines and falls of civilizations, the demand for codification reaches its climax in the penultimate age before a social catastrophe, long after the peak of achievement in jurisprudence has been passed and when the legislators of the day are irretrievably on the run in a losing battle with ungovernable forces of destruction. Well, it's a great pleasure for me to be able to be here with you this evening, to thank the faculty for its kind hospitality for myself and my wife Rona this year in Cambridge, and to celebrate the Arthur Goodhart Professorship of Legal Science, which marks its 50th jubilee this year since André Tunck first held it in the academic year 1972-73, and which has been held by so many jurists more eminent than its present incumbent. My point of departure this evening is, I admit, only obliquely signalled by the rather opaque title I chose for my remarks. To the mind of the common lawyer, the expression legal science generally conjures the impenetrable theories of 19th century German legal philosophers, whereas Arthur Goodhart himself is revered today as the quintessential common lawyer, practical, pragmatic, founder of the Cambridge Law Journal, editor for 50 years of the Law Quarterly Review, interested above all in the law as it developed by common law judges and not in esoteric theory. Well, given this, it's something of a tribute to your sense of collegiality that you turned up this evening at all. Yet, after all, the American trustees who so generously established the bequest for the chair chose to name it the Arthur Goodhart Chair in Legal Science and not just in law. And they specified in their bequest that the expression legal science shall include not only jurisprudence in the accepted sense of the term, but also the study of some of the basic principles of any particular legal system and the study of law reform and contemporary legal problems. And Lord Diplock, in his tribute to Goodhart on his retirement from the editorship of the LQR, referred to his contribution to the science of the law. Well, what did this mean to Goodhart himself? Much of Goodhart's writings were in the form of finely crafted case notes, but there were also some notable occasions when he set out his own philosophy of law. For Goodhart, at least, the idea of studying law scientifically went well beyond being satisfied merely to state the law as it is. Rather, he meant, as he put it in a lecture at the University of Toronto in 1929, quotes, attempting to analyse the various principles involved, to test them logically by fitting them into the law as a whole, and to consider the extent to which they meet the needs of present-day society. In his view, the study of the law in this sense actually craves a crisis. Citing the examples of Bacon, Hobbes, and Bentham, each of whom lived at a time of crisis, he said that it's in times when the supremacy of law is insecure that the best legal philosophy is produced. His wasn't the study of practice devoid of all sense of the purpose of law. And he developed this point in his Hamlin lectures, which are perhaps the most significant account of his overall theory, if you like, of law, which was called English Law and the Moral Law and delivered in 1953, just as Toynbee was writing his volume on law in the study of history. Well, Goodhart critiqued Kelson for its lack of reality in understanding the true nature of legal obligation. In so doing, he offered some important insights about the nature specifically of international law. Now, I'm not suggesting here that Goodhart was blessed with some kind of papal infallibility on this subject. In fact, as historians of international law will know, he was celebratedly on the wrong side of both law and history in terms of the legality of the British invasion in the Suez Crisis. But I still think his insights into the general nature of international law remain of lasting value. He rejected categorically as a fallacy the proposition that international law is weak because there's no sovereign body to command it and that there is a general absence of adequate legal machinery, notably courts. Rather, he said, quotes, international law, like every other legal system, depends on the recognition of its obligatory character, and he saw clearly that in turn the extent of such recognition depends on the strength of the idea of an international community and an underlying moral obligation to obey its rules. Well, what relevance do these insights have for us today and for the future of the science of international law? I guess I've been thinking about this rather deeply this year, both in my writing and teaching, which has been devoted to an examination of the internal operation of international law as a legal system, in particular in the light of the external pressures that the system currently faces. Well, what might treating law as a science have to offer an understanding of the function that international law does and should play? Of course, many different answers could be given to that question, and I should also add that I'm not suggesting that this is the only valid or valuable perspective that might be taken on law. But I do argue that choosing to treat international law as a science means at least three important elements. Firstly, an inductive and empirical approach to the identification of law. Second, the effort through legal reasoning to build relationships between legal rules. And thirdly, a consideration of the higher order principles that lie behind them. And let me just say a word about each of those points because they're, if you like, themes that are going to run through the whole talk. In the first place, it means testing the rules of law against the relevant evidence. And of course, in the case of international law, this includes not only the specific legal engagements of states embodied in treaties and other instruments, but also, and vitally, the actual practice of states in all its decentralized variety. So in this first and primary sense, legal science isn't an abstract exercise. It is and must remain empirically grounded and inductively derived from the evidence. Second, it means seeing how that mass of observable data fits a wider pattern, the system of the law. And what this is about is actually the application of the specific methodology of law as a discipline to the data. As Marty Koskiniemi himself perceptibly observed, legal interpretation and thus legal reasoning builds systemic relationships between rules and principles by envisaging them as parts of some human effort or purpose. He said this is not an academic aspect of the legal craft, it permeates all legal reasoning. But he then added, it may also be rationalized in terms of a political obligation on law appliers to make their decisions cohere with the preferences and expectations of the community whose law they administer. In third place, the science of the law is not and never has been solely confined to what Hersch Lauderpark called the mere registration of the practice of states. Such a limited vision would discourage any determined effort at relating it to higher legal principle or to a conception of international law as a whole. So understanding the underlying principles on which the system is premised, the way in which those principles may help to make sense of what it is important to preserve and provide a secure basis for international law's progressive development. This is the third element that I isolate for the purpose of this evening. Well, in considering the implications of such an approach today, I'm of course not about to claim that international law is some magic elixir that will cure the world's ills, nor even that the current content of all of its detailed rules have any necessary intrinsic merit. My aim this evening is a more modest one. In keeping with Goodhart's vision of what legal science can and should achieve, I do want to suggest that a renewed focus on the fundamentals of the internal operation of international law as a legal system, the distinctive perspective of law as a discipline, might lead us to see the true significance of what has actually been achieved in the 70 years since Goodhart wrote, and what might be at stake in the event that humanity were to lose sight of the merits of the system. This isn't a question of the mere forms of the law, but of the ability of international law to maintain some stability in international relations, while at the same time facilitating change. Because in an important sense, law always draws upon the past to plan for the future. That's actually what law is. As Jutta Brunet and Stephen Toop put it, the dominant views in international relations and in international law scholarship undermine international law's capacity to mediate stability and change because they focus on the surface of the law and neglect the deeper structure of what makes norms law and affects its propensity to promote stability and change. Well, it might seem a bit odd to take up this theme in this university of all places, which has for so long championed the study of international law as law, to the extent that such an approach to the discipline, both positivist and pragmatic, might almost be said to constitute the Cambridge School. Yet at a time when the system as a whole has come under sustained attack, it is, I think, necessary to take stock at a more fundamental level. This is not business as usual. International lawyers cannot, in my view, simply continue to work away on further elaboration or critique, specific or general, of the content of its rules, whilst taking for granted the persistence of the system as a whole. No legal system can sustain itself, as Goodhart well understood, without the recognition by its participants of its obligatory character and in the moral value of adherence. The late Professor James Crawford pointed to the dangers of the current political discourse in 2018 and the risk that might undermine the larger project. So how am I going to tackle this rather broad topic? I proceed in 5 steps. First, I consider the proposition that the era of peak law has passed, as the legislators of the day are irretrievably on the run in a losing battle with the ungovernable forces of destruction, Toynbee's prophecy. Second, I contrast that with the evidence of what has been achieved in the science of international law making, in particular, since the era in which Goodhart was writing. And I'm going to call that under the heading, with the apologies to the wonderful novel by the novelist Anthony Doerr, All the Light We Cannot See. Third, I argue that the most important aspects of international law are, in fact, not the mass of detailed legal rules, but 2 more fundamental elements. And the first of those elements is the coherence with which the disparate parts of international law fit together into a system. And fourth, I take up the second fundamental element, which is the importance of a much smaller set of general principles which embody the communitarian values of international law. Here, the actual practice of the International Court and other tribunals continues to demonstrate the integral character of general principles formed within the international legal system. And I use that expression advisedly in view of current debates in the International Law Commission. And fifthly, I conclude by suggesting that the notion that international law is in some way opposed to or a constraint upon politics is a fallacy. On the contrary, international law is both a product of a political process and makes politics on the international plane possible. But the system as a whole does depend, like all law, as Goodhart correctly perceived, on its participants' underlying moral consideration of the importance of adherence to it. Part 1. Law amidst the ungovernable forces of destruction. Well, considering the state of international law at the outset of 2023, one has the uncomfortable feeling that Toynbee's ungovernable forces of destruction, the horsemen of the apocalypse, if you will, disease, fire, famine and flood and war, have been abroad in the world, with scant attention paid to the processes and rules so carefully put in place in international law. The COVID-19 pandemic appeared to expose to view the impotence of the very international institutional machinery that had been put in place in 1946 to protect humanity against the international spread of disease. Instead, most states immediately retreated into national protectionism, giving rise to what one British newspaper described as the, quote, disunited nations of coronavirus, creating a quarantine of the jungle and notable examples of nationalism in the supply of vaccines, especially to developing countries. It took the UN Security Council over 3 months even to agree a resolution in favour of a global ceasefire as a basic humanitarian precondition to dealing with the pandemic. Meanwhile, and with apparently escalating speed, the world is facing the twin environmental challenges of the climate and biodiversity crises. Yet the United States, a key polluter, notified its intent to withdraw from the Paris Agreement under President Trump, only for the notification to be rescinded following the election. It's never become a party to the Convention on Biological Diversity, participating solely as an observer. The impression that one gains is that participation in this kind of long-term multilateral cooperation, so surely needed to respond to common environmental problems, is always somehow optional and contingent. Or, as the historian Isabel Hull memorably put it in 2018, There is no inevitable march of progress in history or law. Everything that's been achieved can be rescinded, forgotten, tossed away. Then we have an ongoing hot war on the continent of Europe, in which Russia, a permanent member of the Security Council, has invaded another state in a war of aggression aimed at the overthrow of its government and its partial or complete annexation in a manner that constitutes open defiance of the most basic principles governing international peace and security. Yet, against this prevailing zeitgeist, the impulse of states to embody international law in codified form seems undimmed, prompting reflection on whether we have indeed reached peak law. Take the field of international environmental law. Over 423 instruments concluded since the Stockholm Declaration in 1972 in a relatively incoherent set of fragmented arrangements. There is, it seems, almost a compulsion to create new law in response to each new specific problem of international concern, in which one new treaty is layered up on top of the existing framework. Again, take the example of health. In December 2021, the World Health Assembly decided to draft a new treaty on pandemic protection. Well, ladies and gentlemen, am I missing something? I thought that's what we had with the constitution of the World Health Organization, which was committed from the very outset to that objective, and which unusually amongst the constitutions of international organizations has a regulation-making power, which automatically imposes obligations on member states. Now, we might well say, and with some force, that the international health regulations of 2005 proved ineffective in the context of the COVID-19 pandemic. But I ask you, is it really the right response to turn around and frame a new treaty which would require individual acts of ratification by all 192 member states, when all of those states are already a party to the World Health Organization Constitution? Nor is the position any different in other fields of international law. Take the field of trade. The shift away from the comprehensive multilateral framework of the WTO-covered agreements to the pursuit of separately negotiated free trade agreements has been accompanied by an ever-increasing pursuit of detailed codification. The many thousands of pages of such agreements, coupled with their annexes, appendices, side instruments, and interpretative notes, dwarf in length and detail prior bilateral commerce agreements, and indeed the WTO-covered agreements themselves. And yet what they bear witness to, in real terms, is actually a turning away from comprehensive global rules for international trade into regional blocks. If we shift our gaze from particular fields to the general task of codification and progressive development of international law, we see some striking parallels. The International Law Commission, the UN body charged with this task under its mandate from the General Assembly, has undoubtedly, in the 75 years of its existence, created some great cathedrals of codification, which were the result of broad participatory processes and have achieved wide acceptance of states. I'm thinking in particular of the Vienna Convention on the Law of Treaties and the draft articles on state responsibility. Yet in more recent years, the Commission has more often turned to increasingly detailed glosses on its prior work, with its guidance on reservations to treaties and on their provisional application, its conclusions on subsequent agreements and practice, on the most favoured nation clause, on peremptory norms, and on crimes against humanity. Well, I need to be clear here about what I'm saying and what I'm not saying about the work of the ILC. This kind of work can be very useful. Indeed, for example, the conclusions on interpretation by reference to subsequent agreements have highlighted some very, very important aspects of practice that were being largely previously ignored. And the Commission's current work programme does also contain some urgent contemporary questions, not least its work on the impact of sea level rise. To some extent, the Commission may just be confronting the success of its earlier work in that it's so often now working against a dense backcloth of its previous drafts. And of course, the highly consultative nature of its working practices can be both a strength and a constraint. Since the Commission consults closely with states at every stage, it can be sure that when it eventually comes forward with a draft, it will normally garner a measure of support. But what this does is that it also conditions the Commission's output, particularly its ability to engage in progressive development, according to the prevailing general climate of state opinion vis-à-vis the making of international law more generally. Well, reflecting on the implications of these twin phenomena, the scale of the challenges currently facing us and the pursuit of ever more detailed codification, I want to make three interrelated points which underpin my comments this evening. The first is about international law being perhaps a discipline of crisis. After all, the language of crisis is everywhere in contemporary discussions of the role of international law. The UN Secretary General frequently invokes crisis rhetoric in his speeches, and the rhetoric of crisis has been embraced by international lawyers. Indeed, a white paper for the forthcoming 150th anniversary conference of the ILA refers to crises in the plural of and in multilateral institutions. And the most recent issue of the American Journal is devoted as it is to the invasion of Ukraine, described as one of the most significant shocks to the global order. A recent monograph by another American law professor is simply entitled The World Crisis and International Law. As Mekan Mbenge and Jean Dasbremont comment, crisis narratives are back in international law circles. But, ladies and gentlemen, we have been here before. Professor, now Judge Hilary Charlesworth, drew attention to the perils of crisis rhetoric in her 2002 article written in the wake of the NATO intervention in Kosovo. She said that crises dominate the imagination of international lawyers, but warned of the risk that an undue focus on crises produces an impoverished set of substantive principles. I think it is possible to agree with Charlesworth's point and at the same time to draw inspiration from Goodhart's conclusion that good philosophy can be done in times of crisis. What is required is not to continue to churn out new law in an atmosphere of barely contained panic on the basis that our existence on the planet sits at 1 minute before the midnight hour, but rather to take stock of what it is that is really important at the level of substantive principle in the international legal system that we have created, because only in this way can we really move forward. And of course, there's a terrible danger in the language of crisis, because it can be deployed to undermine the predicate for all legal cooperation, namely the idea of legal community. And that is exactly what E.H. Carr, the founder of the discipline of international relations, did when he wrote The 20 Years Crisis in 1939, an attack in which he shared common cause with Carl Schmitt on Lauterpacht's function of law. Carr insisted on the absence of any generally accepted view of the general good of the community as a whole, overriding the particular good of any individual member. This point is as seriously fallacious and dangerous today as it was on the eve of the Second World War. It's a fallacy because it's empirically falsifiable from the actual practice of states and the practice of multilateralism, as I shall attempt to show in the next section, but also because it's built on a false premise that there can be no coincidence between a state's individual interests and the general good of the international community. On the contrary, I argue that all international law is built through a political process in which states recognize where their individual interest and the common interest coincide. So the remedy here is not necessarily more law. We can and should ask whether the current rules and institutional structures are fit for purpose. But behind those questions lies a set of more fundamental justifications at the level of principle. Baroness Honora O'Neill highlights the potential shortfalls of the multiplication of international rules in her 2017 Asser lecture, when she says, rules are always and unavoidably incomplete and indeterminate. Indeterminacy cannot be eliminated by adding further and more detailed rules that go all the way down. Deficiencies in the way institutions and individuals act, therefore, cannot be remedied just by setting additional requirements, more regulation, more accountability. She adds, an even more fundamental issue is that deeper questions of justification are widely avoided. All too often, the only justification offered is an appeal to authority. What's needed, she argues, is an explicit consideration of the ethical justification that underpins resort to law in the international community. Part 2, all the light we cannot see. So, what I want to suggest is that the real underlying significance of the international legal system that has been built particularly in the 70 years since Goodhart wrote, lies in two elements. The first is the creative capacity of international lawmaking through treaties as a process that I've suggested is in the first instance political, because it's created by states through their engagement in treaty making, in which all states participate, but the results of which, of course, are manifested in legal form. We shouldn't be misled, however, into thinking that the particular solutions that states have adopted are set in stone, because on the contrary, the techniques of international law turn out on closer inspection to offer a striking degree of flexibility to accommodate the changing needs of the international community. My second point is that what the international community has created isn't just a kaleidoscope, a jumble of constantly changing different treaty obligations. Rather, what's emerged from all of this is actually a system. We have actually ended up making something that's more than the sum of the parts. Well, I'll come back to that second point in part 4, but in this part I want to address the treaty-making process, considering first some common features of the multilateral treaty-making, and then the comparatively understudied common features of bilateral treaty-making. In both contexts, I think we paid a certain price for the great achievement of the International Law Commission in subsuming essentially all forms of treaty-making under a single umbrella concept of the treaty, with only the most minor nods in the Vienna Convention to differentiation between different types of treaties. Now, of course, in the practical context of law application, that's often of great practical value, but it has, I think, limited the extent to which we have been able to look behind the general treaty form and see some of the distinctive common features of the way in which these different kinds of treaties are actually made. So let me start with multilateral treaty making. And I do so not only because of its preeminent importance to the structure of international law. As James Crawford put it, in the classical international law system, law was assumed to be general and treaties as merely particular contracts, whereas, he said, for us, the real multilateral relations are those under or pursuant to the great multilateral treaties. So it's important, but it's also because an examination of the process of making multilateral treaties encodes a shared practice of states that is itself system constitutive. Let me explain what I mean by that. I think it's rather striking how little attention has been paid by international lawyers to the manner in which this multitude of treaty making can be said to constitute a system. But research, and here I'm about to give a bouquet to the international relations scholars, in case you think I've been giving them a hard time, research undertaken on the basis of a large-scale quantitative analysis of treaty making by Glass, Hoffman and others, has demonstrated the extent to which the multilateral treating has become what they call a taken-for-granted practice of the international system constitutive of both state actors and the international system itself. And the point that they make is that it's a system that survived a number of critical points in which states could have rejected multilateral treaty-making in favour of other forms of interaction, but in the event did not do so. And they mention in particular following the Russian Revolution in 1917 and following the emergence of new states following decolonization. At each of those pivot points in the 20th century, radical new visions of suitable instruments for world order were discussed, but in the end the form that states adopted was the multilateral treaty. And contemporary mapping, which is what they do in this very excellent piece, has shown that it can no longer be seen as a predominantly Western practice, nor, importantly, as a Western imposition on non-Western states. On the contrary, the survey of treaty making which they conducted demonstrates that newly independent states enacted statehood through treaty making in a way not directed at or by former colonial powers, but in a dense regional context. So it's not only the practice of multilateral treaty making itself that's system constitutive, but it's also because this practice generates common elements across treaties. And here I think we shouldn't underestimate the power of human agency in legal innovation. The framework convention is everywhere with us today. It's a household term, whether applied to climate change or tobacco control. And yet it originates in an obscure meeting of fisheries experts at the Food and Agriculture Organization in Rome in 1974. It's a tribute to the wonderful services of the librarians in this great law library that this, one of the few print copies remaining of this report, was disinterred from me at Boston Spa and brought down. So what were they doing? They were preparing the first convention to provide for integrated management of the Mediterranean, the Barcelona Convention, still in force today. And if we read the text of that convention, we find that many of the features which are now so typically adopted, the conference of state parties, the provision for additional protocols under the more general framework, they're all there. And the point here is that was a meeting conducted in 1974 with representatives of the 16 littoral states from North Africa, the Middle East, Eastern and Western Europe. And it was the non-Western states that championed the adoption of the Framework Convention, eventually, but with the initial reservations, but eventually the Western states were brought to the party. So the innovations embedded in the idea of the Framework Convention also support two further observations. The first is the balance between stability and change, which is inherent in the relationship between a Framework Convention and its capacity for elaboration through subsequent decisions and protocols. These forms of decision-making are under-theorized in general international law, yet they have a significant potential to enable the law to develop over time. The second point is what these processes do is embody a highly participatory political process within a legal framework. We might, it's true, regret the cumbersome nature of this process and its vulnerability to political and even commercial pressure, as some prominent experts currently have done in relation to the Climate Change Convention. We might well want to consider afresh what other techniques could be adopted. But what we cannot do is reject the basic point underpinning these processes, which is that multilateral treaties are given life through a political process in which all states are engaged. What about bilateralism? If the processes of multilateral treaty making have been comparatively neglected, bilateral treaties languish in an obscurity of doubtful alleged moral validity. In his celebrated Hague Lectures, Bruno Simmer characterizes the traditional conception of international law as bilateralist, concerning only the delimitation of separate territorial jurisdiction, providing a limited reciprocity-based framework. He contrasts that with all the merits of multilateralism, criticizing bilateralism as a severe obstacle in the way of stronger solidarity. And then he proceeds to proclaim the good news that international law is finally overcoming the legal as well as moral deficiencies of bilateralism. Well, it's true that bilateralism continues to be associated as a technique with the preferences of unilateralists rather than universalists, and plainly it can be used to achieve hegemonic aims, as the United States bilateral agreements which sought to neuter the Rome Statute vividly demonstrate. But what I want to suggest this evening is that bilateralism is not necessarily opposed to community solidarity. It can be used in this way, but in fact, the much more neglected, but actually both numerically and substantively more important phenomenon in bilateral treaty making is the use of the model treaty, which in fact dates back to the very foundation of the United States of America, because the third document which the framers considered along with the constitutional documents was a plan of treaties. And of course the first thing they did, having agreed that, was to send Ben Franklin to Paris and have him negotiate the very first friendship treaty with France. If we jump forward to the present day, the majority of bilateral treaties that are concluded are in fact derived from models. Some of those may well be vulnerable to the claim that they represent projections of hegemonic power, but many not. For example, extradition, mutual assistance in criminal matters, double taxation. In each of these contexts, states may have accepted that reaching agreement on a multilateral basis with numerous other states is not politically feasible, but that has not precluded bilateral agreement from a common template. Nor should it be thought that the use of a bilateral treaty is inimical to multilateral reform when a consensus does emerge in the international community. because that's exactly what Article 30 of the Vienna Convention so cleverly provides for and recently used to great effect in the adoption of the new multilateral base erosion convention in tax, which simply lays across many thousands of double tax treaties a new multilateral agreement applying to all of them. Part 3, coherence, why systemic integration matters now. I had to get to systemic integration at some point in the lecture. Important though these patterns of treaty making are, they give rise to a larger question. How can the numerous disparate elements of international law, varying not only in subject matter but also in membership, be conceived as a legal system, especially in circumstances in which such rules have an inherent potential to conflict with each other, pursuing different objectives? The world of international law is, after all, largely flat. It's made up by the multiple actions of states, each of which enjoys sovereign equality with every other state as a matter of law. It lacks the vertical hierarchy of lawmaking and law-applying institutions that are so characteristic of national legal systems. Yet without some basis for resolving conflicts between applicable legal norms, international law would fail a basic condition of the rule of law, namely a capacity to achieve coherence. Well, one could give a very short or a very long answer to this critically important question. The short answer is that what national legal systems achieve through formal hierarchies of norms and of decision-making, international law must achieve through its internal processes of interpretation and application of the relevant rules. This, of course, is precisely what Article 31.3c of the Vienna Convention instructs the treaty interpreter to do. She must, quote, take into account, when interpreting a particular treaty provision, any relevant rules of international law applicable in the relation between the parties. In the work that I was privileged to do in collaboration with the ILC study group on fragmentation back in 2005, I coined the term the principle of systemic integration for this well-recognized process, and that's a label that seems to have stuck. But what, of course, this short phrase covers is what is, in fact, often a highly complex and difficult process of integrating legal norms. And for the longer answer, ladies and gentlemen, you'll just have to wait for the book, which I hope to complete during my stay with you. But my point this evening about systemic integration is that integral though it is as a matter of technique to the internal reasoning process of the law, we shouldn't mistake its larger significance. The manner in which systemic integration is applied to reconcile different international law norms can indeed be outcome determinative. This much was already apparent on the first occasion when the International Court specifically embraced Article 31.3c in the oil platforms case in order to interpret an exception for essential security interests in a bilateral friendship treaty by reference to the rules of the UN Charter and the general international law on the use of force. And so too, when in Philip Morris in Uruguay, an international arbitral tribunal held that plain paper packaging legislation introduced by Uruguay to control the smoking of tobacco didn't constitute an expropriation of Philip Morris's property right in the trademark, because it was a legitimate use of the police power of the state to act in aid of public health to introduce measures consistent with the WHO Framework Convention on Tobacco Control. Well, the principle of systemic integration has also very recently reached these shores and garnered the attention of the UK Supreme Court with different and outcome determinative results. So as we know, in SC, the court took some care to distinguish its approach in this regard from that of the European Court of Human Rights as an international tribunal, finding that an English court is not competent to determine whether the UK is in violation of the UN Convention on the Rights of the Child because it's an unincorporated treaty when hearing a case on the compatibility of the two-child limit on child benefits with the European Convention. The court distinguished the direct application of rights derived from other treaties from reference to those rules in interpretation and application. Then, in Basfar and Wong, decided just 1 year later in July 2022, a differently constituted court found that it is entitled to take international conventions against slavery into account in determining whether the conditions of employment of a domestic servant by a foreign diplomat in this country constitute modern slavery such that it amounted to commercial activity not covered by diplomatic immunity. At the international level, systemic integration has lost none of its present salience. In Billy and Wong, the UN Human Rights Committee decided an individual communication from a group of Torres Strait Islanders who claimed that Australia is in breach of its obligations under the Covenant on Civil and Political Rights to protect the right to family life and cultural identity by failing to take sufficient measures to mitigate and adapt to the effects of climate change. The petitioners invoked Article 31(3)(c) and referred to Australia's other international obligations under the Paris Agreement and other such agreements. Australia demurred, but the committee took a middle line. It accepted that it's not competent to determine compliance with these other treaties, but it nevertheless held that it is entitled to refer to them in interpreting the state parties' obligations under the Covenant. Meanwhile, as I speak to you this evening, the UN General Assembly is considering a resolution from 16 states championed by Vanuatu, in which my own country also joins, to seek an advisory opinion from the International Court on the obligations of states in relation to climate change. If the resolution is adopted in March, the Court would be asked to determine the obligations of states under international law to ensure the protection of the climate system from anthropogenic emissions, having regard to the UN Charter, the Human Rights Covenants and Declaration, and the Climate Change and Law of the Sea Conventions, and the principle of prevention of significant harm to the environment. A tough assignment for the Court, one might think, but what this formulation invites it to do is to consider the legal obligations of states as a coherent whole, derived from both multilateral treaties and general principles of international environmental law. Well, there is a view in some quarters that the principle of systemic integration is just another device in which, to quote a former US trade representative, quotes, activist judges impose their own policy preferences and institutional preferences on states. This is a dangerous misperception. Properly understood and applied, the principle of systemic integration, so far from being such a device, in opposition to the interests of states, actually operates as a check on an excess of judicial power, because it constrains the tribunal's development of its jurisprudence under a particular treaty by requiring it to see how it fits with states' other obligations under other relevant rules of international law. Just the point that the former Vice President of the European Court of Human Rights, Angelika Nussberger, made when she criticised the court extrajudicially for creating a kind of a lex specialis interpretation of the convention, contrary to the approach of general international law. And since the principle requires taking into account only rules of international law that are applicable, it respects the principle of state consent by limiting the frame of reference to the rules that are applicable to the relevant states. This, in other words, is a coherence formed of sovereign will not imposed upon it. It does not substitute the policy choices of states for those of the judges. Rather, as Professor Georg Nolte, now also a judge on the International Court, observed in the context of the WTO jurisprudence, reference to other treaty rules operates, quotes, to preserve a policy space for domestic regulation where a single-minded trade-oriented approach might have suggested otherwise. Well, this isn't to say that the choices about the respective weight to be given to different legal obligations binding upon the same states are necessarily easy, nor that reasonable minds cannot differ about the decisions that are made. But after all legal systems produce hard cases. The question for lawyers and judges is how well supported by reference to reasons those decisions are seen to be. Since of international adjudication were nothing more than the substitution of judges' policy choices for those of the states, there could be no conceivable reason for a state to submit its dispute to binding third-party determination according to law, as they so commonly do. Nor is the process of finding coherence between legal rules simply a matter that's consequential for the internal purposes of the legal system. It also matters greatly for the larger purposes of the human society that international law exists to serve. As Professor Anne Orford has recently observed, quotes, "It is a mistake to think that trade agreements and environmental agreements and human rights agreements deal with different domains or different relations. They deal with shared issues of social relations." Seen in this light, international law, as Judges Higgins, Bergenthal, and Koymans wrote, seeks the accommodation of conflicting values and not the triumph of one norm over another. This is the process that Goodhart advocated for the scientific study of law when he said that it meant attempting to analyse the various principles involved, to test them logically by fitting them into the law as a whole, and to consider the extent to which they meet the needs of present society. Part 4, General Principles of International Law. If then, as I have argued in the previous part, the enterprise of law, including international law, inherently entails a search for coherence amongst its disparate rules, what role might general principles of law play in this process? This question has taken on renewed salience as a result of the decision of the International Law Commission to take up the topic of general principles of law in its current work programme. Though recognised as the third source of international law applicable to the International Court in Article 38(1)(c) of the Court Statute, the content and role of general principles within the international legal system has long remained shrouded in obscurity and controversy. It had indeed a controversial birth in the discussions of the commissions of jurists that framed the statute back in 1923. In academic discourse, this controversy continues, not least because of the unfortunate choice of language that the framers chose in 1923, general principles of law common to civilized nations, with all its colonialist overtones. There is, moreover, a suspicion amongst some states that references to general principles may be a form of custom light, a means by which international tribunals can escape the rigours of determining customary international law into a world in which principles are freely invoked at the discretion of the tribunal. Well, let me say at once that I understand both of these concerns, but at the same time I'm seriously concerned at the current tenor of the debates within the Commission on this subject, which do read as if the world has not moved on at all in the century since 1923, and which risk reducing the utility of the Commission's work on this very important issue. In its current working draft, the Commission accepts general principles derived from national legal systems, provided they're established by a rather exhaustive approach of wide and representative comparative analysis. But a number of members, despite the efforts of the Special Rapporteur himself, Essex Bermudez, displayed considerable hostility to the idea that general legal principles might be derived or formed within the international legal system itself. The first draft of the conclusions accept that there might be a very small list of principles that are intrinsic to the international legal system, maybe the sovereign equality of states, Pacta sunt servanda, but gives only the most grudging acknowledgement that this is without prejudice to the possible existence of other general principles formed within the international legal system. Well, dear listeners, this will not do, either as an accurate codification of the function that general principles of international law actually play in the contemporary international legal system, and still less as a signpost to progressive development. And if it continues on this path, the Commission may stunt a critically important means by which the international community of states itself has chosen to develop international law, and an important means by which international courts, not least the International Court of Justice itself, achieve coherence between the different rules of international law. Because this point is so important, I need to be absolutely clear about what I'm saying and what I'm not saying. I agree that the invocation of general principles of law is not a substitute for a proper determination of the content of the law that is applicable to the dispute between the parties. It was just such a substitution, or sleight of hand, if you like, that disgraced, frankly, the arbitral award of Lord Asquith in the Crucial States Arbitration in 1952, leading him to hold that it would be fanciful to apply the law of Abu Dhabi to a commercial contract on the basis that it was nothing more than purely discretionary justice applied in a very primitive region. Well, in a recent international arbitral award, which, because it's recently been upheld in full by a Swiss federal Supreme Court and is therefore in the public domain, I can mention, we took the opposite view, declining to substitute an alleged general principles, there the clean hands doctrine, for a proper determination of the applicable rules of national law to determine an allegation of criminal illegality. So any determination of general principles of law formed within the international legal system does require clear evidence of its acceptance as such by the international community of states. It's not enough just to assert such a principle, there's got to be evidence. But an account of general principles that relies principally on a process of transposition from national legal systems would give a seriously distorted account. Judge Yusuf, sometime president and still judge of the International Court, has been quite frank about this. He accepts that the court doesn't tend to refer to Article 38(1)(c) because of its unfortunate, to say the least, formulation, but he stresses continuously in speeches, including to the Sixth Committee of the UN General Assembly, the importance of general principles in the actual work of the court. He said this: "The question of coherence in international law is an existential one. The lack of an organised legislature has often triggered fears about the possible effects of contradictions between international laws, between international legal norms." He says, "General principles of law have proved effective in helping the court to address both structural problems of lawmaking in international society and to promote coherence." It's significant that amongst the examples of such general principles of international law that Judge Yusuf singled out as having been recognised as such by the court are non-intervention, the prohibition on the use of force, the sovereign equality of states, and territorial integrity. These are all, of course, principles enshrined in the Charter and which have also been recognised by the court as rules of customary international law with jus cogens status. But it is just these most basic principles of international law that are at present being so openly flouted by Russia in its war against Ukraine. So what does it really add to describe these norms, as states commonly do, as general principles of international law? Well, in my view, part of the answer to this question lies in reflecting again on the significance of the most important enduring material source, the Friendly Relations Declaration of 1970. In which there are no less than 47 references to principles throughout an 11-page document, but nowhere do the framers explain what they mean by principles. Well, looking again at that declaration, as Jorge Viñuales encourages us to do in his excellent recent collection, especially at a time when its precepts are being so directly challenged, I'm struck by two things. The first is that the framing of these principles was an act of the international community that engaged the widest participation of states, particularly developing states. As Georges Abissave wrote at the time, in 1973, the adoption of the declaration was a major success for third world states, who had recognised that these principles provided them with a much-needed protection. The result was an exercise in progressive development and not merely a codification. This was in no sense a conception of general principles as a projection of hegemonic Western imperial power. The significance of the declaration lies not merely in the fact that it demonstrates possibility, indeed necessity, of reaching agreement on fundamental principles in times of geopolitical polarization or multipolarity. It also lies in their function of, as it were, promoting coherence in the interpretation of other rules. And we can see a similar process in the development of international environmental law, in which a field which too is dated from the 1970s in all its modern conception. In view of the time, I won't walk you through the successive pronouncements of the International Court recognizing general principles of international law. But we could come back to that in discussion, but the developing jurisprudence of the court is, of course, of the first importance in an area of law that concerns the very survival of the planet and of human life on it. In this sense, general principles in international law perform a very similar function to reasoning by reference to principle in any legal system, guiding the application of legal rules where the latter are uncertain or in conflict, as Neil McCormick has so perceptively observed. Yet, as Judge Yusuf recognised, that their function in promoting coherence may go beyond their internal value within the system, because they may also, as he says, ensure that a legal system properly reflects the values of the society it serves in general. So, in conclusion, I want to return to connect the theme that Arthur Goodhart took up in his Hamlin lectures with the current challenges facing international law. I argue that the notion that international law is in some way opposed to or a constraint upon politics is a fallacy. On the contrary, it is both a product of a political process and makes politics on the international plane possible. But the system as a whole depends, as Goodhart correctly perceived, on its participants' underlying moral consideration of the importance of adherence. Of course, it was exactly this false distinction between politics and law which Sir Herschel Lauderpacht unmasked in his great work on the function of law back in 1933. And it's this idea of an international community that is most at risk in the current resurgence of appeals to the siren call of state sovereignty as an expression of a conception of an individual people that is capable only of distinguishing between friend and enemy. Arthur Goodhart's insistence that these anterior principles have what he called a moral dimension calls specific attention to that which the framers of the UN Charter acknowledged when they referred in the preamble to the need, quotes, to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. The rapporteur of the drafting committee at the time made clear that this was not a recipe for stasis in terms of the content of any particular rules. Rather, what the framers had in mind was a much more fundamental choice. Of course it was a fundamental choice. It was a choice between the resort to armed force, which they had so experienced, and the conduct of international relations according to the rule of law. In this context, reference to general principles of international law really do matter, because they express fundamental values that make peaceful cooperation possible. The point was well made by Ambassador Martin Kimani, Kenya's permanent representative at the United Nations, in a speech to the UN Security Council on the 21st of February 2022, condemning Russia's purported recognition of Donetsk and Luhansk. He pointed out that if on independence African states had chosen to pursue states on the basis of ethnic, racial, or religious homogeneity, we would still be waging bloody wars these many decades later. Instead, he said, we chose to follow the rules of the OAU and the United Nations Charter and agreed that we'd settle for the borders that we inherited, the principle of uti possidetis, not because our borders satisfied us, but because we wanted something greater forged in peace. So it was rather refreshing to find up front in the G20 declaration of the 16th of November 2022, in a meeting hosted by Indonesia, significantly, a clear declaration that, it quotes, it is essential to uphold international law and the multilateral system that safeguards peace and security. This includes defending all the purposes and principles enshrined in the Charter of the UN and adhering to international humanitarian law. So, the conclusions that I draw from this overview of the results of my research as applied to the current state, some 70 years after Toynbee's prophecy and Goodhart's Hamlin lectures, may now be stated very shortly. Firstly, I think humanity does currently face numerous crises that imperil the bases upon which we cooperate for our common future, but I don't think we're facing ungovernable forces of destruction. Secondly, the solution is not just always more law, more and more detailed rules, more codification, more institutions, but thirdly, rather, it is to refocus attention on the essential elements of the framework that states have created, which is overwhelmingly the product of a political process in the post-decolonization era, in the creation of which all states participated, and which, so far from being inflexible, is in fact a highly flexible system. Fourthly, in evaluating the significance and adequacy of this system, it's critically important to address what binds it together, the means of integration and the general principles of the international legal system, principles themselves so largely created in the post-decolonization era, reflecting contemporary values. But ultimately, however, international law, like any legal system, depends, as Arthur Goodhart reminded us, upon the recognition of its members of the moral obligation to respect it and abide by its precepts. Well, perhaps I can be forgiven for closing my remarks on this day, Waitangi Day, New Zealand's national day, with a reference to what the then New Zealand Prime Minister, Peter Fraser, said in plenary at the San Francisco Conference in 1945 on the framing of the UN Charter. He said this: the failure of the League of Nations was a moral failure on the part of the individual members and not due to any fundamental defect. The League of Nations failed because its members would not perform what they undertook to perform. It failed because of the recession that took place in public morality in the face of the rising tide of fascism. It failed because the rule of expediency replaced that of moral principles. I would therefore stress, he said, that unless in the future we have the moral rectitude and determination to stand by our engagements and our principles, then the procedures laid down in this new organisation will avail us nothing, and the sufferings and the sacrifices of our people have endured will avail us nothing, and the countless lives of those who've died in the struggle for security and freedom will have been sacrificed in vain. Thank you very much.